So that is tonight's topic, getting repairs done. I'm Michael Grinthal. I'm a lawyer at TakeRoot Justice. I've been a housing lawyer in New York City representing tenants since 2007. Um, and it's always a pleasure to work with Cooper Square Committee and the amazing work that they do and that all of you do organizing to fight for tenants to keep your homes affordable and for your communities. So I want to thank you for that as we start. As we go tonight, if you have a question where you need clarification of something, just put up your hand or put something in chat, and I'll ask the Cooper Square folks if you can just watch the chat since I can't always see it very well while sharing my screen. If folks have questions about your situation, let's wait. Let's do those at the end of the session, especially once the recording has stopped and you can share your situations more privately. All right. So TakeRoot Justice is a nonprofit legal services office. We provide legal support as well as research and policy support for grassroots groups like Cooper Square Committee that are working to dismantle racial, economic, and social oppression. Okay. So tonight we're going to be talking about repairs, but I want to start just by reiterating that New York tenants have the right to safe and decent living conditions. And that includes working appliances and fixtures, heat and hot water, which the landlord must pay for. Tenants cannot be made to pay for those things. Electricity and gas, depending on your lease, a tenant might have to pay for those things. But the landlord has to make sure that the systems in the building are working so that you can actually get what you're paying for. Extermination, repainting every 3 years, fire safety, smoking carbon monoxide detectors, sanitary trash storage and removal, clean public areas. So in addition to repairs, landlords are required to provide all of these services. You also have the right to repairs. The New York City Housing Maintenance Code requires that the landlord post a 24-hour phone number in a public area of the building, a lobby or the hallway, and that it is a number that you can call 24 hours in case of emergencies. They're required to provide timely response to complaints. Buildings with more than 8 units, 9 units or more, must have a live-in super or some other arrangement to provide 24-hour janitor services. There are special laws governing lead paint and mold. So when those come up as conditions that need to be fixed, there are very specific laws that the landlord has to follow in how they do that in order to keep you safe, keep your neighbors safe, and make sure that those things don't recur. In addition, repairs to plumbing, electricity, or carpentry or renovation have to be done by licensed professionals. And since everybody in New York always gets that and every landlord always provides that, everything is great and we don't need to do a training or to organize or do any legal actions. But just in case things were to change, why don't we go through the rest of these and talk about, what we can do when these things don't happen. Okay, so specifically, folks have probably encountered this before, but New York City law requires that from October 1st to May 31st, during the day, the landlord has to provide sufficient heat so that it's at least 68 degrees Fahrenheit inside and 62 degrees inside at night. Earlier, if folks may remember, this law used to be different until a few years ago. It used to depend on the numbers used to be much lower. It has been amended by by the city council, and so now and also the heat season has been extended. It used to, I think, be only November through April. Now it includes both October and May. Similarly, um, the landlord is required to provide hot water. This used to be, they used to have different requirements for day and night, but it's simplified now. Every day of the year, 24 hours a day, 7 days a week, the hot water must be able to run a constant at least 120 degrees Fahrenheit. Okay. So we're going to spend most of this time talking about what happens when these aren't being provided and what we as tenants can do to get a landlord to make repairs. I'm going to talk about three different tactics here. The first one is a legal strategy, bringing a housing court case against the landlord. It's called an HP action. The second item is tenants' right to withhold rent, either by themselves or as a group. And then finally, for those who are rent stabilized, making a complaint to the state agency DHCR. So we're going to look at each of those in turn. Now, no matter which strategy you're using, the first thing to do is to document the problem, the repair that needs to be made, the service that needs to be restored. Notify the landlord in writing. I know, some buildings have a super that is available so that people can just go down and talk to them. But it's always also important to put it in writing to the landlord by email if you're using email. Text is not ideal, but if it's what you have available, I recommend that. Or even just a letter that you mail or hand deliver. The reason is that a lot of these strategies later on are going to require that you show that the landlord knew that the problem existed. So you want to have a paper trail in writing showing everything that you told them about it and when. Call 311 to get an inspection. That can be, for most of these conditions, that's going to be HPD. But for conditions that go to the structure of the building or things involving like the boiler or the furnace or an elevator, that's going to be the Department of Buildings. And then some conditions are also for the Department of Health and Mental Hygiene. So that could be like air quality issues or mold. If you know which agency you want, you can call them directly, but 311 is supposed to route your complaint to the one that's most relevant. And Cindy just put in the chat a great tool by our friends at JustFix NY that lets you quickly generate a letter to your landlord to tell them about conditions. I know calling 311 can be a frustrating experience. And a lot of people come to the point where they say, what's the point of calling 311? Because even if the inspector comes and says there's a violation and that gets recorded, HPD doesn't do anything about it, right? They do not enforce their violations except in a few select buildings. But it is really valuable to get those violations placed in the record. And we'll see why as we talk about each of these strategies. So if you're in court or you're withholding rent or you're going to DHCR, it gets you a long way to be able to show that there's an HPD violation or a DOB violation. And unfortunately, The opposite happens, that when you're in court, some judges become very, very skeptical, or even stop listening if they don't see an HPD violation. Then finally, documenting it yourself. So that can be taking pictures of conditions, keeping a written log for things like heat and hot water. It's often very difficult or impossible to get a violation placed because the outage might not coincide with the moment that the inspector comes. And I'll share a little later on uh, how you can keep your own log of heat outages in a way that you'll be able to use in court. And it's worth doing this even if their violation is placed, because violations don't tell, for example, how big the hole is or how much water is coming through the water leak. And so it's really valuable to have photographs or videos showing just what you're actually suffering through. So this is an example of a log that you can use for heat and hot water outages. Again, it's really hard to get violations placed for these things. So what we recommend people do is simply keep a log, get a thermometer. It doesn't have to be a fancy thermometer. And what's important is that you take regular readings, not just when the heat is out, but at, say, the same time every day. Just take 5 minutes to look at the thermometer, write down the date and the time, where in the apartment you took the temperature, and what the reading was. The reason you want to do that regularly is because if you go to court on this, you want to have a record of the temperature that you can show you kept regularly. And without going too far down the rabbit hole of the sometimes very, convoluted rules of evidence in court, you have a better chance of getting this log into evidence if you're in court and getting a judge to pay attention to it if you take readings regularly and you write them down right at the time that you take them. For location in the apartment, you should use the same location. It should be somewhere towards the middle of the apartment, not the bathroom or kitchen, which can have different temperatures than the rest of the apartment. Not right by the door, right by the window, but something that really is going to show what is the overall temperature in the apartment. If possible, something I've seen people do that is really helpful, but you can do this or not depending on the tech you have available. But in addition to writing down the temperature, some people will take a picture of the thermometer, just to prove that that's what it says. That still requires some work in court, but it definitely helps because so now the judge doesn't have to solely rely on your reporting of it. Okay. And you can do the same thing for hot water. You can use the same log. Obviously the location is different. You will have to do that in the kitchen and bathroom because that's where the water is. Okay. So the first thing we're talking about here is a lawsuit in housing court. It's called an HP action. HP used to stand for housing part way back in the early 70s before we had a housing court, because it was brought in a part of the civil court that was called the housing part. The whole housing court is now the housing part, but the name has stuck. So it's an HP action, and the HP doesn't really stand for anything anymore, just like KFC. So what this is it's a lawsuit in housing court. It's brought by a tenant or a group of tenants, which is a really important point in the law, against a landlord. And what it seeks is an order that the landlord do repairs or stop harassment. And we're going to focus mostly on repairs here because harassment is a topic that really deserves a whole training to itself. So we're going to talk about the pros and cons of each of these strategies, right? So the pros for housing court case is you're on the offense, right? As we see in withholding rent, you might wind up in housing court on the defense with the landlord trying to evict you. And we'll talk about how to make that as safe as possible. But a nice thing about an HP action is, the worst that can happen is you don't win and nothing happens, right? You can't get evicted in an HP action. You're not going to get an order to pay rent or to change your behavior or anything like that. It is solely about whether violations exist and then repairing them if they do. Another good point is that the law specifically says that a group of tenants can bring an HP action. And group HP actions can be very effective because they present the picture of what the whole building looks like. The landlord will take it seriously because it involves potentially a lot of fines for them. It allows you to deal with the landlord as a group, which is always, always, always more powerful and a better way to deal with the landlord. Uh, and, you know, finally, if you are organizing in your building and you're having a hard time getting the landlord to meet with you, not that this is the only way to do it, but one way to get them to meet with you is to bring a lawsuit, right? And then they'll literally have to be there in court. Another pro for this is it is probably the fastest of the three strategies that we're talking about. And you get a court order, right? The cons to this are this is probably the most time intensive and energy intensive. You have to go to court. Court moves slowly. Every time you have a court date, you should figure it's going to be a whole day. Again, just because they are massively overcrowded. If you are not protected by rent stabilization or good cause, and this is not just for an HP action, but for anything that you do, beware. The landlord may try to retaliate and not renew your lease. There are laws against that. But considering that we're only having this discussion in the first place because the landlord has already violated some laws, we're obviously not going to pretend that landlords always follow the law. That is absolutely not a reason not to take action. And there are a lot of ways to take action as safely as possible. And I know I'm going to sound like a broken record on this, but the number one safest thing you can do is whatever you do, do it as a group. Because the landlord is not going to evict the whole building. One other downside of this is the law doesn't provide, you can't get damages in an HP action. You just get an order for repairs, right? Whereas we'll see with the other two strategies, there are ways that you might actually be able to get compensated for what you've gone through. Okay. Oops. Um, so how to start an HP action? Do not go to 141 Livingston Street because that's in Brooklyn. In Manhattan, go to 111 Center Street. Sorry about that. I forgot to update this slide. You go to the clerk's office on the second floor. When you go to the clerk's office, there's one window that you start at, no matter what you're there for. You go up to them, you say, I want to bring an HP action. They give you some forms and they direct you to another window. It is, as much as any court experience can be, it's actually pretty straightforward. The forms that you fill out have pretty basic information on them. The things you'll want to have ready are the names and apartment numbers of everybody who's bringing the case, the names and addresses of the landlord and anyone else who's in charge of the building. So that could be the managing agent, could be the super. And you can find these by looking on HPD's website. There's a link there. We're going to share the slides, so you'll have access to these links. But landlords are required every year to register their names and addresses with HPD so that tenants can find them. Well, I think actually probably the motivation of passing the law was to so that HPD could find them, but it also allows tenants to find them. So you can always use that address when suing them in a lawsuit. And if they come back and say, oops, that's not our address anymore, the law is well written enough that it says that's their problem. That if you serve them at the address they have registered, that's good service. And if they've moved and failed to update their address with HPD, that's their problem. And then finally, you'll want a list of all the repairs needed. And it's good to have this and not just a list of the repairs, but where they are, right? What room they're in. At this time, you can also fill out a form to request that the court order HPD to do an inspection, right? So if there's any violations or repairs you want to list here that haven't already been the subject of a violation that HPD placed, you can ask for an inspection here. There's a $45 fee for starting a case in housing court, but there is an exception for people who are low income. You can get it waived. There's some forms to fill out there. They are usually pretty accepting and receptive to it. In the past, we've had some judges who got really kind of belligerent about it and argued with tenants about whether they really needed a fee waiver, but that was years ago, and I haven't heard reports of that for a long time. It's just generally nobody who works at the court wants to create work for themselves. So if you fill out a form saying that you're low income, they'll just pretty much take it. Once you fill this out, it actually first has to be signed by the judge. So it gets sent upstairs from the clerk's office to the judge who hears HP actions. And that judge has to sign it because then it's an order ordering everyone else to come to court on a certain date. So that can involve having to sit for a while till that judge is ready to look at what's been brought to them and sign it. Once it's signed and you have a return date, you have to serve the papers on the landlord. You'll be given instructions on how to do that. And you can usually do it by mail, although it is possible to serve by delivering them in person. We're not going to talk too much about service tonight, but in general, you don't need a process server to serve papers, but you can't serve them yourself. The person who serves the papers has to be not a party to the action. Right? Non-process servers, non-lawyers can serve papers a couple times a year under the law. So unless you've been asking the same person to keep serving papers for you, you can ask your friend or your cousin or your coworker, and they can do it. But again, the clerk will give you instructions. The address you serve it on is the address registered with HPD. All right. So this is fast forwarding a bit to contempt. Let me actually insert something here before we get to contempt. A couple things about the HP action. So when you go to file it at the clerk's office, you won't see a judge, except to the extent that you might go up and sit in the courtroom and wait for them to sign it. You'll get a return date, and that's when you come in and you can see the judge. Every HP action by law, you have to also name HPD as a party, and they get served. It's easy to serve them, they'll take it by email. But the point being, since they are the agency that's in charge of enforcing the code, they should be involved. Um, if there are civil penalties or fines imposed on the landlord, it's HPD that collects them. So this means that in the courtroom where HP actions are heard, which is called the HP part, which is the housing part, just like the ATM machine and the PIN number. But we have probably more important changes to fight for, although that continues to be irritating. But it means that in that part, there are HPD lawyers there all day, every day, because they have to appear on every single case that comes in that part. And depending on the specific lawyer, they can be very helpful to you if you don't have a lawyer. Uh, though you're naming them as a respondent, a defendant, they're on your side. Their job is to get the repairs done, and to get the violations cleared. So when you get to court on the return date, find the HPD attorney, who usually sometimes they're in a room off to the side. Sometimes they're just sitting up front, depending on how the courtroom is laid out. You can ask the clerk, or you can ask the court security officer to point them out to you. If you approach them and say, "I'm a tenant," or "We are tenants, and we have a tenant initiated HP action here today," they will, in my experience, usually sit down with you, go over it, and join you when the landlord's lawyer comes in, right? And be part of the negotiations about repairs. It varies from lawyer to lawyer. Some are really zealous and they'll really fight, and some are less zealous. But again, it's always worth going to them. Not only because then you've got a lawyer on your side if you don't already have a lawyer representing you, but also the leverage in an HP action is civil penalties. When a landlord doesn't fix violations within a time period, they have to pay to the city. And it's HPD that collects, it's HPD that has to argue for it in court. So if you don't have HPD there, then no one is, raising that leverage of civil penalties. But if you have the HPD lawyer there, they can say, if you do the repairs by a certain date, we'll waive some of the penalties. So usually an HP action, I'd say, like 95% of all kinds of lawsuits in America, most HP actions settle. And they usually settle with what's called a consent order, which is a written settlement in which the landlord acknowledges the existence of the violations and agrees to repair them by a certain time. And then there will be a provision about the civil penalties, whether they have to pay them, whether they only have to pay them if they don't meet the deadline. This is another place that the HPD lawyers are helpful. They have a regular form consent order. And that it's much better to use that than to write up something fresh, or even worse, let the landlord's lawyer write it up. And that very often happens on the first date, but it's always possible to throw a wrench in the gears in court. I should know that's what I probably spend most of my time doing when I'm in the other courtrooms in the courthouse. And landlords lawyers can do it just as much as we do it. And so, you should be ready for the possibility that you might have to come back a few times, even if the case is really simple. And if a case doesn't settle, if the landlord, just said, "I do not agree these conditions exist and I'm not going to agree to anything," you may have to go to trial. Uh, and that's where it's going to come in really handy to have photographs that show not only that a condition exists, but the extent of it, right? How bad it is, how urgent it is for it to be fixed. That's where it's really helpful to have the heat logs that you kept in a regular daily manner. The judge will take a look at it. And this is where it's really valuable to have the 311 HPD violations on the record, right? So on her desk, the judge has a computer. They can look up on the HPD website your address and apartment and see what the violations are. And there's a great piece of the law that says that if a violation is there on the HPD website, the court can presume that it exists. The landlord can try to rebut that presumption, can try to disprove it by showing their own evidence. Here's a photograph of it corrected. But the great thing about this is that if you have a violation placed and it's on the HPD website, the burden shifts away from being on you to prove that the condition exists, and the burden instead goes to the landlord to prove that it doesn't exist, which is just a huge relief in court. And in fact, most HP judges are in the habit of just looking at the HPD website. And if they see violations there, they will turn to the landlord's lawyer and be like, why are you denying this? Why don't you just sign a consent order? And unfortunately, on the other side, if they don't see a violation there, they get really skeptical and sometimes push hard on tenants and being like, I can't do anything about it. Do not believe them when they say that. You do not have to have an HPD violation placed in order to win in court. You can prove the condition exists in other ways with your other evidence. It's just that judges sometimes kind of skip over that part. So don't ever let a judge tell you, I see no violations here, there's nothing I can do. The answer is, well, I've got photographs, and if we have to go to trial, I'll provide them. Okay, so we've finally caught up to our slides here. So what happens if the landlord doesn't follow the court order, right? They're already violating the law, so why should we assume that a court order is going to make them do it? So sometimes it does make them do it because now they face civil penalties if they don't do it. Some landlords, just like anybody else, react strongly to being taken to court and having a judge, wearing a whole, robe and everything, tell them to do something. So it does, in fact, sometimes just spur them to action. But very often it doesn't, or they do some of the repairs, or they do some really superficial repairs. And so this is where the HP action can get more time consuming, right? So if the landlord doesn't do the repairs by the deadline, they're violating a court order. Someone who violates a court order is in contempt of court. And so, the judge is not monitoring what happens. They only know what we bring to them. So then it's on the tenants to bring a motion, ask another order to show cause, asking for a court date to hold the landlord in contempt. And there may be another hearing, or there may be another settlement setting new deadlines. But what starts to happen is that people who are in contempt of court can have to pay damages, right? So I said earlier, you can't get damages from this route. Not 100% true. If the judge finds a landlord in contempt of court, they may actually order damages to you. They have a lot of discretion about this. And sometimes if the if the landlord's violation of the order seems just like technical, or they seem to have acted in good faith but just didn't finish on time, judge might not award damages. They may, sometimes it may be on the second contempt order that they order damages. Um, Either way, what's happening at this stage is that the money that it could cost the landlord is getting bigger. And often at this point, it starts to come in the form of like additional civil penalties or damages for every day over the deadline that it takes them. So the heat does start getting turned up. And again, this is time and labor intensive, but the the stick that you're swinging is getting bigger and bigger. Once you start going into contempt, and we find, with the worst landlords, this is where stuff really happens at the contempt stage. Um, but again, that is a lot of work to get to that point. All right. Um, just want to take a moment, step back before we start talking about the next strategy to ask if anybody has any questions about HP actions, something that I said that you want clarification on, or something I didn't go into. Again, if you have a question about your situation, please hold that till the end when we're no longer recording. Okay, I see a few things in the chat. Let's see. Can you, whoops. Christine is asking, can you clarify contempt of court versus order to show cause? And I know that post in the chat is from a few minutes ago, so it may refer to things we wound up covering. You reposted it. So, I mean, the difference in those things is that they're two parts of the same thing. So contempt is finding. You're asking the judge to find the landlord in contempt. The order to show cause is the way you do it, right? It's what you file in court. An order to show cause in general is you're asking the judge to sign an order that all the parties come to court on a particular day. So you need to do that because once the case is settled, there's no more court dates. It's no longer on the calendar. So if you want to go back and say they haven't followed the order, you need to file an order to show cause. And what the order to show cause is asking for is that the landlord find them in contempt. Let's see. I see multiple dwelling law requires a certificate of occupancy. So yeah, I'm not sure if it's a question, but you're right. This is a separate thing. Uh, Buildings built after a certain year that I'm forgetting in the 20s have to have a certificate of occupancy. If they don't, that can be a basis on which a landlord can't collect rent. Uh, so Anthony asks, is simply taking the landlord to court a legitimate cause for non-renewal? It is not a legitimate cause. And in fact, it never has been since we first had the anti-retaliation law, which I think goes back at least to the 70s, if not the 60s. The tough thing is that it's really hard to prove that your landlord is evicting you for it with a retaliatory intent, just like claims of discrimination. The laws have been weakened a lot by people who have an interest in them not being enforced. And since you're having to prove basically what's in the landlord's head, that's very difficult to do unless the landlord just, says it right out. And some do. I mean, I see plenty of emails that say, you want to call 311 on me, screw you, I'm not renewing your lease. But especially larger landlords who have lawyers handy tend not to just admit outright. And then so this is not to say that like absolutely you should not be afraid to bring an HP action or do any of these actions. But it is really worth, before it, thinking about, based on what you know of the landlord, what their reaction might be, so that you can begin to take actions that'll help protect you. Like, that's great, Christine, in the chat, record meetings and calls, so that if the landlord's gonna pressure you to do something or threaten you or admit the reason they're doing something, you'll have it. Right. So let's move on to the second strategy, withholding rent. We have, like most but not all states in the US, a law called the Warranty of Habitability, which says that whatever your lease says or doesn't say, or even if all you've got is a verbal agreement, it is deemed to include a provision that says the apartment will be habitable. It will be free of code violations or any other conditions that prevent you from using it to the fullest. And if the landlord violates that, right, by allowing conditions to exist, then you may have the right to have your rent reduced. The idea being you're not getting what you're paying for, so you can pay less. And this is where we get, the statutory right, the legal right to withhold rent. We always had the right to withhold rent because it's ours, but now we have a law that states this and gives certain procedures and rules for doing it. So, like the other strategies, this has pros and cons, right? The pros are that this is, you are using the most powerful leverage you have, your rent, right? Um, Losing rent is almost always going to cost more than paying civil penalties, right? And you don't have to wait for a judge to order it or HPD to collect it. The whole reason the landlord's even in this business is for your rent. So you're going straight to the heart. Another pro of this is that, like I said, the warranty of habitability says that if your apartment's not up to code, you might be able to get your rent reduced, right? You may be able to get what we call a rent abatement. So you might actually get something for your trouble here. The cons are that this is definitely the riskiest, right? Because what you're doing is basically provoking the landlord into taking you to housing court for non-payment, where then you can exercise your right, and make these arguments. We'll talk a little bit about how to try to mitigate the risk, but it's never gone. And it's incredibly, incredibly important when withholding rent to make sure that every penny that you've withheld is there, set aside. Because, first of all, things can go wrong and you might suddenly wind up having to pay it. But even if you win, right, you're getting your rent reduced by a percentage. And let's say that a judge orders your rent reduced by 40%, which is actually, at the upper end of the spectrum. And I think, we generally consider that a win. The flip side is that you still have to pay the 60%. And you don't want to be in a position where anybody gets evicted just for a different number, right? So we want to make sure that we have our ducks in a row before withholding rent. Like I said, the fact that this is part of the law gives us some structure to follow. And so if you're going to withhold rent, this is what to do so that you get the full power of the law. One, as before, notify the landlord in writing of the repair, right? If the repair isn't done, I would not recommend starting to withhold, like something springs a leak and that day you email the landlord. I wouldn't suggest starting to withhold rent at that point. This is something to do if the landlord is not taking action and not responding. So if that's happening, Then again, notify the landlord in writing, right? This condition hasn't been fixed. The landlord hasn't done anything. And that you're going to start withholding your rent until it's fixed. Again, a written record, a paper trail, super important here because you're going to wind up in court, and in court, it's just all about the paper. You want proof that you sent it to them, right? So an email can be good. If you're sending it as a letter, send it certified mail, return receipt requested. So you get a little green card that says they got it, right? Then, and I should say, when you notify the landlord in writing, be as specific as possible and descriptive as possible about what you're asking them to fix, right? So that there's no argument later on about like what they have to fix and what they don't, right? And then, as I said, set aside all of the rent each month, right? The reason for this is that you're going to get taken to housing court for non-payment. There's a good chance of it. When you're in housing court for non-payment, you can make the case go away and the threat of eviction go away at any time just by paying what the landlord's asking for, right? It's not to say you should do that, but if something goes wrong, right, you're in the middle of doing this, and then your family emergency, and you just can't keep going to court. Something else happens, you just can't continue on with this. You'll always have that parachute, right? You can just pay the rent, whole thing goes away, right? Not a great situation because you haven't won and you haven't gotten the repairs done or the abatement. But again, that's like the escape hatch. That's the safety hatch. Because anytime we're in court, no matter how ready we are for it, stuff happens, right? And you get sick at the last minute and can't make a court date, Um, and so it's never possible to be completely safe, but holding the rent is a pretty good way that you'll be able to, sleep well at night, knowing that if worse comes to worse, you can always just hit eject. Now, the warranty of habitability allows us to withhold rent individually, but like everything else, it is much more powerful to do it as a group, especially with bigger landlords who, they won't like not getting your rent, but they can live with it, right? But if it's a third of the building or a half of the building or more that's not paying rent, you will definitely have their attention, right? If you're considering a rent strike, definitely talk to the organizers at Cooper Square, and they'll probably bring in one of us lawyers. There are important questions to ask each other before starting a rent strike. It's important that everybody getting involved has the exact, the same picture of what you're fighting for and what's happening. Rent strikes are incredibly powerful. And since the pandemic, we've seen more and more of them because during the pandemic, there was a massive swell of rent strikes. If you consider them all together, arguably the biggest rent strike in New York history, which before this was, I think the record was held by a Harlem-wide rent strike in the 60s. So a lot more people are doing rent strikes, and that's really good because, again, it is the most powerful tool you have. But some things to consider before doing a rent strike are, you want to have a critical mass, which is, a rule of thumb would be at least a third of the building, but more is better. Because if there's not enough of you to really have leverage, then the landlord can just get aggressive and come after the people withholding their rent. And then those few people might find themselves isolated. Other things are that you really don't want to do a rent strike unless people are depositing their rent each month into a shared account. If you're represented by a lawyer, the lawyer will have an account that can go into. You can also open a simple account at the bank in the name of the tenant association. But the thing is, think about, look at your neighbors, everybody look at each other and think, you know, how in 6 months are we going to be uh, ready to hold each other accountable and collect rent from each other? And if the answer is no, we're not ready to do that, that is okay, right? It can mean that there is going to, you need to take some more time to build up the tenant association, to build trust. And there's nothing wrong with that. It's just, rent strikes, there is going to come a time in the rent strike when things are going to get tough and the landlord's not responding, still not doing rent. Something's going to happen where people start to have arguments with each other. It's natural anytime people organize. People are going to begin to look at each other and think, like, I don't agree with what they're doing. And all of that is natural and fine. And groups of people can deal with it. But it's worth asking, are we a group that has built our relationships and our trust enough that we're going to be ready to go through that? And if not, the answer is not don't do a rent strike. The answer is um, that there's some more organizing to do. There is a great toolkit on rent strikes on the Right to Counsel Coalition's website. There is under organizing and COVID-19, but that's just because that's when they first put it up there during the COVID rent strikes. The rules are generally the same now, although those materials might, at times mention things like the emergency rent assistance program and the eviction moratorium that were going on during COVID, which obviously we don't have now. But they're really excellent materials because they talk both about the law, but also, what it's like to be on a rent strike and what to expect. All right, let me stop for a moment and ask if anybody has any questions about the warranty of habitability or withholding rent or rent strikes.
I do.
Done.
Hi. Yeah, I do have a question about withholding rent. Um, I just want to get some clarity on the action I took. I had a situation during COVID where.
So, sorry, and I just want to say, you might be better to ask this
Okay, now
question at the
perfect.
end when we're no longer recording,
Okay, so more
because I know
generally.
Cooper.
Okay.
If you want to ask the question generally, or if you just want to,
Yes.
we'll be on at the end, and the
Okay.
recording will be off, and you'll be able to go
So
into
more
as much detail.
generally, if you do withhold rent, as you said, more than likely the landlord may start a proceeding, right? If
Mhm.
you are given during the process, you say you're successful and you get a rent abatement or some kind of compensation, is there a set
Mhm.
percentage or amount? How is that determined?
Yeah, that's a good question. There is a percentage. There's no rules. The judge kind of combines a gut check with like what has been done in comparable other cases. Um, and as a lawyer, people ask us all the time, like, what do you think the abatement will be for this? And the best we can usually do is like give or take 20%. Um, so yeah, I mean, the only thing we can say with some certainty is if the conditions are so bad that they make it actually impossible to go into the apartment, then if the judge finds that that exists, it would be a 100% abatement. That's the only percentage that, has a clear formula.
Thank you.
Yep. It also, just to make things possibly more complicated, it's also based on how many months the condition existed. The abatement will only apply to the time period that you actually lived with that condition. And so since, if I've got 10 conditions in my apartment, but some of them started in 2023 and some of them started in 2024 and so on, um, it can be a handful to keep track of all of that. Not impossible. I mean, it's just a list and maybe some arithmetic, but it does make it harder to predict like what the numbers are going to be in the judge's order at the end of the case. Okay. Um, Christine notes you must put it in a separate bank account. Um, for obvious reasons, you do not want to put it in one tenant's bank account unless you have just the, most best relationships between tenants that ever existed in a building. Um, to open a bank account in the name of a tenant association, they usually just want you to be able to say who is the president, who is the treasurer. So before you do it, you can just at a meeting, decide who the president and the treasurer are in whatever method you think is best. And those will be the two people who can sign things for the account. Again, if you're represented by a lawyer, like TakeRoot, we have, an account where we can hold clients' money. Okay. So now we're on to the third strategy. And unfortunately, this only works for tenants who are rent stabilized. It doesn't even work for tenants who are protected by good cause, just rent stabilization and rent control. Uh, so the pros of this is by far the easiest thing to do. You fill out a form, you email it or mail it, and then everything else happens in writing. You send it in, the DHCR sends you a letter responding. They usually send someone to do an inspection. The landlord submits if they have any opposition. They do it in writing, and DHCR forwards it to you. This is easy. Another pro is that it it can lead to a rent reduction. The remedy, if DHCR finds that conditions exist, is they order the landlord to roll back your rent by the last lease increase. So if are paying 1,050 and your last lease was 1,000, then the rent gets rolled back to that, and that's all you have to pay until the landlord shows DHCR that they've fixed it. The Your rent also gets frozen for that period, right? So, if in the meantime, lease renewal time comes around and you sign a renewal lease and you pick a 2-year renewal and there's a percentage increase, um, that increase is legal, but the landlord can't collect it until they get this rent reduction order lifted. So it's not a huge amount of money, right? It isn't in the league of a rent abatement. It might be depending on where your rent is at. It could be double digits a month. Um, any money is helpful, but we're definitely not talking here about the amount of money that is going to hit a landlord significantly in their wallet. Right? I've never seen a landlord be like, "Oh my God, I better act because 2B is paying $16 a month less right now." And in fact, we've seen rent reduction orders just hang out for, like sometimes, we come into a building, start working with the tenants, and we, do a FOIL request to DHCR and find that, there's a rent reduction order from 2003, right? That like the landlord just didn't care enough about to like pay the postage to oppose it. I'll say if they let it go for that long, you're going to start talking about real money. But, this is not the heaviest leverage. The cons are that this is the slowest. DHCR is really slow in processing complaints. So it's going to be months before you hear back from them. It could be like a year before you get an order. for what it's worth, when you finally get the order, it is retro, right? It goes back to when you first applied. And then, of course, the other problem is that this is not available for non-rent stabilized tenants, which even for rent stabilized tenants can mean that you won't be able to have a lot of neighbors joining you in the tactic. And Christine, you asked in the chat about filing as a group. And yes, um, so there are two kinds of rent reduction orders. And when you go on DHCR's website, you can click for either one. One is for apartment conditions, right? The thing that exists just in one apartment. And then there's another for building-wide conditions. So, things happening in the common areas or, the front door or the roof or the cellar. And for common area, for building-wide complaints, uh, you can have as many tenants as there are in the building who are rent stabilized sign on to it. And everyone who signs on to the complaint will get the rent reduction, which, I'll say two things about that. I mean, one, that does start to, sort of increase the pot of money that's at stake for the landlord. Another thing we found, I think anyone who's tried to organize in their building knows, how much work it takes to get as many people to join as possible. Um, it's the Lord's work, but it's hard. And we found that, if there are a lot of rent stabilized tenants in the building, a group building wide rent reduction is actually a good way. People generally are, that tends to interest people. People will come out and join in on that. And so it's a real good, just something to float, to be able to say, hey, if you come to the meeting, you can get in on this. And any tenant who doesn't join in, the complaint doesn't get a rent reduction, even though they're living with the same building-wide condition. If I could rewrite the law, I would change that. But in the meantime, it does mean we can say to our neighbors, like if you don't come out to the meeting, you're going to miss the bus. So the way that you do this, at the end, is pretty simple. Notify the landlord in writing of the condition. This used to actually be a requirement. You actually had to submit to DHCR a copy of the notice you gave to the landlord. That's no longer required, but it's still recommended. Because again, these are all escalation tactics. If the landlord does repairs when you ask them to, that's great. And there are other things that we can turn our energy to. So these are things to do when the landlord doesn't make the repairs. Call 311, get HPD to place a violation, document it yourself. Everything that we do for the last two strategies. And then you fill out the complaint form online at DHCR. And you can, it's a PDF, it's fillable. You just fill it out. You can print it out, fill it out, mail it in. You can do it on your computer if you're comfortable doing that, and email it. It really is, and really all you're putting in there is your contact information, the landlord's contact information, and what the condition is. So this is a 15-minute form at most. You don't have to serve it on the landlord. You send it to DHCR. DHCR sends a copy to the landlord and asks for their response. When they get the landlord's response, they send that to you and ask for a response. And that goes on for as long as they want to get arguments or information from you. But usually the next thing you'll get is a request, there'll be is a notice that you get in the mail that says we're going to send an inspector on such and such a date, be home and ready. But there's a number you can call if you can't do that time and need to reschedule. So they'll come out. If they see the thing, they'll say, you get a rent reduction. You'll get an order from DHR in the mail that says, what the conditions are, tells you and the landlord to roll the rent back by one increase and freeze it there. and then, you know, DHR is done, right? They, case closed until the landlord sends them their own application saying, we fixed it, we want to lift this. And then you get usually another inspection. Um, so yeah, it's easy to do. It's only, you can get together and, everybody in a meeting and fill out the forms on the spot. Um, and, and at the end of the year, it's not going to be enough money to make the landlord regret becoming a landlord, but it's not nothing either. So, okay. Um, Again, we will share these slides. You don't have to write down all of these URLs, but these are just a lot of different websites and services and apps that are useful to tenants, either in documenting, finding out about your landlord, documenting conditions, communicating with the landlord, looking up what conditions, what violations already exist. All right.